This is number one. So U.S. persons, and the reason why I'm getting into these sort of technical classifications and descriptions is just so that we don't get totally confused later on when we start talking about FIRPTA and Pandora Papers and all that and structuring. And of course, this is, everyone's going to get a copy of this presentation afterwards. So, you know, it's like there's so much information here. We don't expect you to remember all this information. It's just more of a guide to sort of catch where you could see potential issues. So U.S. persons, for FIRPTA income tax purposes, that includes U.S. citizens, which anywhere in the world, U.S. citizens are taxed wherever they are in the world, regardless, by the IRS. Green card holders, exactly the same thing as U.S. citizens. Even if they leave the U.S. and they think, okay, I'm not leaving the U.S. anymore, until they actually file, not only after they've given their green card back to the Immigration Service, but also they have to file an exit papers with the IRS. If they don't do that, the IRS will still consider them as tax residents. U.S. corporations, U.S. partnerships, LPs, LLPs, and LLCs where there's more than one member. So if it's taxed as a partnership, a domestic partnership, it's considered a U.S. person, even if all the underlying members, shareholders are foreign. And any individual who passes the substantial presence test, and this is something that gets a lot of non-residents. So they just spend way too much time here, and then boom, they become a U.S. resident, which is really bad for a lot of rich people because then their whole worldwide assets will be taxed. So next one, this is just U.S. persons continued. So if any of these conditions apply, we're talking U.S. citizens, green card holders, substantial presence test, then such person is considered a U.S. tax resident at the very least for that tax year, right? That means they're going to be taxed for income tax purposes on their worldwide income, just like any other U.S. citizen. And it doesn't matter if they're considered a tax resident in their own country for the most part. There are some special rules that are able to mitigate the circumstances in certain situations, but for the most part, even if you're a tax resident in another country, you'd still be considered a tax resident in the US. This is important because you might get clients that just say, oh, well, yeah, I spent a lot of time here in the US, but I declare all my taxes in France or Brazil or Mexico. So yeah, I don't have anything to worry about. It's a common misconception. That's why I bring this up, right? And it doesn't matter if they spend a significant amount of time here, or they're a green card holder, or they're a U.S. citizen, then they are going to be subject to the U.S. tax system, whether they like it or not. Yeah, so never assume anything with in this respect. All right. Your client should always have a healthy dose of skepticism. When in doubt, they should always contact counsel or an accountant to ask these questions. Now, what's a non-resident alien definition? Well, basically, a non-resident alien is anything other than those classes of individual that I described. But basically, a non-US citizen, non-green card holding individual who doesn't spend a substantial amount of time in the United States. It also includes foreign trusts, it includes foreign corporations. Those are basically any corporations that are established outside the United States, any entities, foreign entities as well. So corporations, foreign LLCs, foreign SAs, limitadas in like South America, what have you, and foreign partnerships as well. Those are all considered to be non-US persons for both FIRPTA and both for income tax purposes as well. And then lastly, apologize, this should be a 3, is US domiciliary. Now, US domiciliary, just bring this up because this is a very unique classification in the tax code, and it purely is to do with US estate and gift taxing. And this is going to be important to understand a little later on in our presentation. It's a subjective criteria. It basically determines whether or not you would be considered classified to qualify for the higher exemption for US citizens for US estate taxes, current 11.5 million, or whether if you're a non-US citizen, non-domiciliary, you would only classify for the $60,000 exemption, which for most people is almost nothing. And it's a subjective criteria. It really depends on various factors. There's no one rule fits all. The rule only applies to non-US citizens, just so that we can keep this simple, right? US citizens always qualify for the higher estate tax exemption. Various factors analyzed: time spent in a place, where you work, have a family, have a home. A green card is a strong factor, but it's not dispositive. You can have a green card, but be considered a non-domiciliary. Undocumented persons can be considered a US domiciliary, right? I give this classic example where someone enters the country illegally, right? They cross the border and decide, I'm never going back, it's too dangerous, whatever, no economic opportunities, I'm staying in the US even without papers. And so they struggle and struggle, then they win the Powerball or something along those lines, and are given millions of dollars, but they have no paperwork. But would they be considered a domiciliary and be allowed an $11.5 million exemption? Absolutely, they're domiciliary, even if they have no papers. Just the last point that I just mentioned, U.S. domiciliaries have the same U.S. estate and gift tax exemption as citizens, which is currently 11.5 million versus the 60,000. It's a huge, huge difference, and it makes a big difference when you have clients coming into the country wanting to buy a $3 million apartment, right, in New York or Miami, for instance. Rarely is it a good idea to have it in their own individual names due to that such a short exemption. If they were to pass away, there could be a big tax bill. So let's just get into a few basics here, and I just touched upon these. It's just the U.S. estate and gift tax exemptions, right? So the current federal exemption is $11.5 million per person. This, however, is set to expire in January 2026 and to revert to about $6 million or sooner. There are some proposals in Congress right now looking to reduce it back down to around 6 million before that time frame. And what does that basically mean? That means that if you have assets up to $11.5 million, you're going to pay zero in federal estate taxes, right? You only start paying on the first dollar above 11.5 million, or should I say your estate, because you would have been the client, or you would have been deceased. But after 11.5 million, the amount is quite shocking. It's 40% of fair market values of any at date of death, right? So if you have someone that has an estate of 21.5 million directly in their name, then $10 million is going to have $10 million would be subject to a $4 million estate tax. Non-citizen and non-domiciliaries, they're only taxed on their US-based assets, right? But obviously, as we mentioned, the much lower exemption exists for $60,000. So if they have US-based assets that exceed that $60,000, then they are subject to the federal estate tax of up to 40%. So if you have, for instance, a foreign individual that purchases a $2-3 million apartment here in New York in their own individual name, and then they pass away, then they're going to get a $60,000 exemption on the first $60,000, and then everything, pretty much the entire value of the apartment, would be subject to estate tax. And those are graduated rates for at that point, but it goes all the way up to 40% will kick in after $1 million. So you're probably on a $3 million apartment. That client is probably, or their estate is probably looking at a tax bill of around, I would say, at least $1 million, at least $1 million. And this includes not only U.S. real estate like condos, but also stock and co-ops held directly in the name as a taxable asset. So and it's problematic. It's very, very problematic because they don't realize this. Our system, our whole system is geared to facilitate transactions, to purchase real estate. We want to make it easy for people, for foreigners to come here and purchase real estate. It's what keeps our economy going. But the dirty little secret behind our tax code, which isn't made very readily available to these clients is that once they die, all of a sudden Uncle Sam comes and decides to take a big chunk out of the value of the asset, right? And they don't really understand that or realize that until it's too late. Once they pass away, there's essentially an estate tax lien on the apartment or the co-op, and the only way that you can get rid of that is to actually file a tax return, pay the estate tax. It takes about a year for them to process it. In that meantime, it just remains frozen. And on top of that, if they don't have sufficient liquidity in the estate to pay that, they're going to have to sell the apartment at like fire sale prices, and obviously no one wants that. So I just created a very simple table, right? U.S. real estate ownership risks and income taxes. So whenever someone comes to us and says, okay, well, what's the best strategy? Should I just put it in a company? Should I just put it in a trust? And there's really, this is just to give you an idea that there's really no one size fits all. It's a balancing act. There's no perfect solution. There's no silver bullet here. It really depends on many factors: clients' objectives, how long they're going to keep the apartment, what they're going to use it for, whether there's any U.S. citizens that are going to be utilizing the apartment, whether they eventually intend to become U.S. Residents. So you've got a U.S. estate tax on one side, and then, okay, so you don't want it in their own individual name. So we have various types of strategies in which we can mitigate U.S. estate tax. Typically what we do is we put it in, we utilize either a trust, an irrevocable trust, or we utilize what we call a foreign blocker company, which is basically an offshore company that perhaps owns a U.S. corporation, which then owns the real estate. So in that respect, that blocks the U.S. estate tax. But there are income tax consequences, because income tax, the most viable, the most efficient tax strategy for income tax purposes is to hold it in your own individual name, right? So when you put it in a trust or in a irrevocable trust, or you put it in a corporation, then your income tax bill is naturally going to go up, whether you sell it, whether there's like a corporate franchise tax here in New York State. So it's kind of a give and take, basically. And again, this is just sort of to give an idea of that kind of balancing act and that give and take in these situations, because so often you do have clients that come to you and ask for that silver bullet, right? And this is just to give the idea that there is no silver bullet in these situations. They should really ideally go to counsel either ideally before, or even during the closing process, during contract signing. We get this so much. We get, we have Andrew and his team, and they handle all the closings, but then it's a foreign client. They need help. They're uncertain. So then we get involved. And basically what we do is we try to come up with an efficient strategy, right, that fits them. And if we need to create entities, we do it. We put language in the contracts that allow us to do it, and we can get entities set up within a week or so, right? So it's really key to get this right at the beginning, or right before it's titled in their own names. We'll get to that in a little bit later. That's usually due to FIRPTA issues.
And Chris, one other thing that I want to point out is that, just to let you know, the clients, they're not going to give up the deal because they have to, for example, to form a company, to make a structure in order to do that right, because this is going to help them in the future. We've been working for the past 8 years with these foreign clients buying real estate here, and that's what they want. So it's very, very important to think about the estate tax consequences and make sure that the property there is a structure in order to purchase this property. Or in some situations also, we tell clients, for example, to acquire life insurance in order to protect from the estate taxes, basically, that they can use the proceeds to pay for the estate taxes. But right, that's usually the best way would be, I would say, to structure, as we just mentioned, through a foreign corporation, which would own a U.S. corporation.
Yeah.
Which in turn would.
The key is, don't be afraid to tell your client to get advice. I think there's a lot of hesitation with that, because obviously and very understandably, some lawyers out there just like to gum things up. They like to overcomplicate things. They like to slow down the deal and potentially, have the effect of killing the deal. We're not about that at all, because we understand that the client wants to buy this property and they want to make it work. So when we come into a deal, and there's a foreign client, and there's the potential need for a structure, we try to make things as easy as possible on all sides. The last thing any of us want to do is to kill the deal, right? We want to keep things moving, but at the same time, you want to be able to protect the client's interests. But by protecting the client's interests and letting them know that, look, if you're kind of giving them that holistic approach, you're adding value to them. Essentially, you're giving them an extra additional amount of service. They'll trust you more, and then they'll send their friends, they'll recommend you, and so forth. So always have them looking for assistance in these matters for foreign clients, especially when they're investing so much money in real estate. They'll really appreciate it in the long run.
Absolutely, Chris, especially because if it's not structured right in the beginning, we'll probably have to fix it later on. That's
right.
what is going to happen.
We've had that a lot. We've had that a lot, where clients come to us after the fact, and we say, well, you're going to get a really big estate tax if you pass away. And then we give them the options. None of them really that great. And then they're essentially saying, well, why didn't anyone tell me about this beforehand? So and they get frustrated by it, right? They feel like they were only given half the story. So by having this knowledge and being able to tell them, or at least spot the issue and have them seek assistance, that will really give them added value. So I just wanted to touch basically on the Pandora Papers a little bit, give you the latest. So I'm sure a lot of you have already heard about it. So what's the latest? Well, this is yet another huge leak of confidential information from several service providers in offshore jurisdictions. This is the largest leak since the 2016 Panama Papers, right? So it's actually even bigger, slightly bigger. The amount of information that was leaked back in 2016, well, this just supersedes it by a couple of, I think, gigabytes or something like that. And what is in that information? What exactly is contained in it? Well, it's confidential information on shareholders and directors of offshore companies in several jurisdictions like Cayman, BVI, Panama. And obviously what's hitting the news right now is there's a lot of celebrities and politicians around the world that's showing that they're shareholders of these offshore companies. And then, but however, an important point to note is that it's unclear at this time if any illegal activities have been committed. Just to give you a bit of background, we deal with offshore companies all the time. It's a very common planning strategy for us in this area of structuring for U.S. estate planning. Foreign blockers are a very popular strategy, and also in at least when you're purchasing real estate here in the U.S., as I'd mentioned, to protect against U.S. estate tax. So there are perfectly legitimate uses for it, right? There is nothing inherently wrong with using these companies. So it's the real question here is, if there's illegality, is whether it's being properly declared in the home country jurisdiction, right? And this, we're just talking about non-US persons, because for US persons, it's rarely a good idea to have an offshore company. There's very few really good reasons why it makes sense for a US person to hold any participation in an offshore company. So you might notice in the news that you're never really going to see too much information about US persons actually being involved in these offshore companies. And that's because the service providers, and we've actually worked with these service providers that are listed there, these service providers typically shy away from US persons. They don't want to deal with US persons because they know it's not a good idea. The IRS really comes down hard, not only on the taxpayers, but also on any sort of service providers. So they really shy away from it. But at the same time, that doesn't mean that US persons don't use it. You might have also heard in the news, if you at least read the Miami Herald like I do, that one very famous foreign person who got caught up in this was Julio Iglesias, who owns several BVI companies apparently. in which he used to hold various portfolios of Miami properties, I think up to like $100 million of property. And so obviously it's coming out in the papers, and now they're trying to create a big scandal about it and say, oh my goodness, he was this member of offshore companies. Well, when I look at that as a trust and estates advisor for international clients, the first thing that comes to mind is, well, that's pretty intelligent planning. That's probably what I would have recommended for him to do, right? As a non-US person that has a very low exemption amount, it's good to have these foreign blocker companies, especially like $100 million worth of US real estate. Because at the end of the day, his estate could potentially be on the hook for like $40 million in US estate taxes, which is completely preventable, right?
And Chris,
So,
in case of also even like Brazilians, for example, not only they are protected from the estate tax, but also they are allowed to defer any kind of income tax, in all of the profits of this company. So that's why it's very, it's a great deal for them, because they can invest here in the US through the offshore company, and they only have to pay, for example, income tax if the company distribute dividends to them, which is
right.
the opposite in case of like US persons. So.
Yep. Yeah, and sometimes you can we work with clients. Obviously, when a client comes to us and wants to set up a structure, we always have to look at the two sides, right? So we don't only look at the US side, we've got to say, well, how is this going to affect you in your home country when you report this? And sometimes it makes more sense, for instance, to create an Ontario limited partnership that's typically for European clients as opposed to like a BVI company. But there are several strategies out there that work for the vast majority of clients. The question here is, in terms of illegality, is, at least in Julio Iglesias' situation, was he declaring this to his home country? I believe he's not a resident in Spain anymore. I think he's a resident of the Dominican Republic. So it's really a question of what does the Dominican Republic consider this? Is this an issue in the Dominican Republic? And the question could very well be, there's no issue. Right. So, but it remains to be seen. It's early days anyway. So, but don't buy too much into the hype and the of the media, right? Because really, a lot of these stories tend to be just non-stories. They're just looking for these big names. It was the same for Tony Blair. Even though there was nothing illegal about it, it's just
taxes, right, Chris? That's what we kind of try to do, like
exactly.
strategy and put a plan together. So
yeah. All right. So now that we touched upon those basic tax rules, and also let's get into the FIRPTA rules, right? Because I think there's so many questions regarding FIRPTA rules. I'll try to be as concise as possible here, just because due to some technical difficulties we've had, where I don't want to spend, I don't want to go over our time, and I also want to be able to answer any questions that anyone may have. So let's begin. I'm sure a lot of you are real estate professionals and you've probably already heard of FIRPTA, but for those that you haven't, there's just a very general background on it. So what is FIRPTA? It stands for Foreign Investment in Real Property Tax Act. And it basically applies whenever a foreign, and that's a non-US person. So remember back to the beginning of our presentation, what a non-US person is. It's basically when a foreign non-US person transfers a US real property interest. And one thing that I have to make clear about FIRPTA is that we tend to deal in these contexts of these withholdings of individuals, but it is a monster of legislation. I mean, it's just some of the most complex legislation that an attorney could ever deal with. We're just keeping things very simple here. But just to give you an idea of how complex that legislation is, when someone, U.S. real property interest is in of itself a very specific definition of FIRPTA. U.S. real property interest just doesn't mean an interest directly in U.S. real property. It can also mean an interest in a company, right, that owns the U.S. real property. So the shares of a corporation, typically a domestic corporation, can also be considered a U.S. real property interest, right? So the law tries to be as very broad as possible to prevent any sort of misuse and workarounds.
Would be
The
what, please? I think it's more than 50% of the assets held by the company, right? Then
correct,
we
correct.
consider it as real property interests.
Correct. And
Mhm.
there's different treatment if it's a domestic corporation versus a foreign corporation. So it's always worthwhile to keep that in mind. The withholding requirements for individual non-US transferors is 15% of the sale price. All right. So if it's $1 million sale price, $150,000 withholding, right? That has to be done and sent to the IRS. It's important to note, and a lot of clients get very confused by this. They say, what, this is a ridiculous income tax I'm being charged. But it's worth noting that isn't the income tax necessarily. This is just a withholding mechanism, right? It's to ensure eventually that the IRS gets payment of any tax owed. So they might even be making a loss on the investment. Maybe they purchased it for 1.2 million. They're selling it for 1 million. Does the FIRPTA still apply? Yes, it does. They have to, typically what happens is they have to ask for a refund of that and they have to prove in a tax return filing filed the next year saying, look, I actually lost money on this, give me my FIRPTA withholding back. And then after so much time, the IRS will eventually refund that. But the IRS wants to make sure they get their money and that the foreigner will just take all the money and then split from the US with it. Withholding must be sent to the IRS within 20 days of closing. After that, there are big fines and penalties. So yeah, after 20 days of closing, that must be sent. And the buyer has liability for any unpaid tax and penalties if there is a failure to withhold or timely send in the withholding, right? So that's why it's so strictly construed. The onus is really, under the law, the onus is really put on the buyer, because a foreign individual can just take the money and run. The IRS could try to run after them, but good luck with that. So the onus is put on the buyer, because what does the buyer have? The buyer has US real property that the IRS can still attach and seize. So both sides take this very seriously. Now, there are certain exceptions to the mandatory 50% withholding, but I'm just going to stress that these exceptions, they're most of them are very narrow exceptions, and they almost certainly don't apply for most real estate that you're dealing with in the New York City area or Miami. The most common one is that what we call a non-foreign affidavit. So that's just basically an affidavit saying I'm a US person. So you don't have to do a withholding, right? That's basically the seller just giving that affidavit. And that's the most common way to do it. Once you get that affidavit, no FIRPTA withholding is required, right? So, but they have to put a social security number down, and they have to declare the US person under penalties of perjury. So most people think, oh, why don't foreigners just do that? Well, there's a good reason for that. It's because, one, under penalties of perjury, they could be criminally charged. Someone that facilitates it could be potentially criminally charged. Withholding agents such as escrow agents could be subject to penalties. The buyer, if they have reason to believe this isn't true, can also be subject to penalties. So that has to be taken really seriously. There is another exception, and that's exception. Okay, well, they don't qualify for the non-foreign affidavit. What else can we do? Well, there is an exception for if the buyer intends to use the property as a primary residence and it's low value, right? Low value, we'll get to that in the next slide, but that's basically like 300,000. It's almost nothing. There's also an exception for what's called an 8288B certificate of withholding request, and we'll get to that in more detail a little later on. One last point that I want to make out is that I've been getting this it's a fairly common question. The client comes, oh, but I'm doing a 1031 exchange. Doesn't matter. 1031 exchange is not a valid exception to withholding. There still needs to be a withholding done. Unless they fit into one of these other exceptions, right? And yes, FIRPTA can complicate a 1031 exchange, but it's still technically required for that the FIRPTA withholding be carried out. So I just mentioned this very, very briefly in my last slide, but there are some common issues with these FIRPTA exceptions. The first is the primary residence low value exception, right? So this is limited to properties under $300,000. yeah, good luck finding something for under 300K in New York or Miami, right? So that's already out of the question anyway. But to make things worse, let's say, for instance, okay, there's a house or something in upstate New York for 300K that they're selling. Well, the whole primary residence exception is that it has to be declared that it's going to be the primary residence of the buyer, right? Not that it was the primary residence of the seller. So what happens is the buyer must declare they will use the property as the primary residence. And most buyers will not want to do this. And I don't blame them. As a buyer's attorney, I would advise them not to do that. You just don't want to put these things on paper, right? It just creates a liability when none would either exist. And they're not mandated to do it too. So this is exception almost rarely never works. It usually maybe with related parties or friends or something along that. And the 8288B, and this is the 8288B certificate of withholding, also called the early refund exception that I mentioned. There's limitations due to current severe backlogs in the IRS. And again, we'll go more into that into detail. The bottom line is there are currently issues with all the FIRPTA exceptions, right? It's not an easy withholding to maneuver around. So what is this 8288B certificate of withholding application exception? Well, these are the very, very basics, because again, I don't want to get you guys bogged down into details. This is just to give you basic ideas of what there is out there. But the 8288B application for a certificate of withholding is basically a request to the IRS to ask for a reduction of the FIRPTA withholding, typically to the amount of income tax actually owed. So what you do is you prepare an application. I've done these many, many times myself. You calculate the adjusted basis of the property, put together a package with the evidence of it, and then you send it to the IRS. So there's $1 million, and the most common scenario actually is when there's a loss, right? So there's $1 million. The client purchased it for 1.1 million, but is selling for 1 million. And so he's actually going to recognize a loss, right? So basically the application is going to say, hey, look, the client bought it for 1 million, 1.1 million, selling it for 1 million. He's getting a loss. Please cancel out this withholding. It's not needed, right? Because there's not actually going to be any tax owed. There's some tricky issues though with certificate of withholding applications. One of them is that the foreign seller must have proof of a FIRPTA withholding was made or an exemption applied when he or she purchased the property. And that can be really difficult to do because they might not have the documentation, right? They might have purchased the property like 20, 30 years ago. And I've had cases like this. You had a client that purchased it back in like 1990 or something like that, and they just don't have all the documentation. The documentation's incomplete or missing. In that case, you can't do a certificate of withholding. You're going to have to do the full FIRPTA withholding and send it to the IRS. Now, one of the benefits of the certificate of withholding application is that if the application is sent on or before closing, the FIRPTA withholding can be maintained in escrow until a response is sent from the IRS. And I've used this many, many times in the past, at least pre-pandemic. And what happens is you enter into a FIRPTA escrow agreement with the buyer. It's held in either the buyer or seller's escrow, attorney's escrow account. And then once the determination from the IRS is sent, then saying, okay, no FIRPTA withholdings required, escrow releases it to the foreign seller. That used to actually be a very common strategy. It was a great strategy because the IRS was actually somewhat fairly efficient with with reviewing the withholding applications. They would do it within 90 days, and they were pretty good about that too. And then came along the pandemic, and the FIRPTA office in Ogden, Utah, shut down pretty much for a whole year. They weren't reviewing anything. So they were getting all these packages, and they were just piling up and up and up and up and up. And none of them were getting reviewed. And then finally they get back into the office and start reviewing. But now they've got this huge backlog to work on. So now what happens? A review process that took 90 days is currently taking now 9 to 12 months. And we don't know when they're going to be done with this pandemic. We really don't, especially considering there was a lot of real estate activity last year as well. So the 8288B can be sent after closing, but the withholding must be sent to the IRS, right? And again, it's also called an early refund application, which made sense before the pandemic. Now that's a complete misnomer. So how do we typically deal? And another few things as well about certificate of withholding drawbacks just compounds on this issue with the backlogs, is that the IRS has full discretion to reject an A288B application. And they sometimes do. A lot of the applications I used to send, they would get approved, no problem whatsoever. They might ask for some additional information. You send it and they approve it. But sometimes just unexpectedly, they'll just either not agree with the number, or they'll just refuse it outright, or they might send a request for information to the wrong address, and it's their fault, but they'll then you get a denial in the mail saying you never responded, and then you have to send in the withholding, and that decision is final no matter how much the IRS has made a mistake. And then if denied, withholding must be sent in anyway within the 20 days of decision. Maintaining FIRPTA escrow in escrow means that filing for a refund via tax return is unavailable due to the funds maintained in escrow account. The IRS cannot refund what it never received. And then, due to the current backlogs, depending on the timing of the closing, if it's end of year, for instance, it may be fast to just send in the withholding and file a tax return requesting a refund, which is required anyway, right? And current backlogs of like 9 to 12 months, well, escrow agents, I already saw hesitation with them wanting to hold it for like 90 days to 120 days, which was typically what we put in escrow agreements. They're already kind of hesitant about that. People just want the transaction done and over with. No one wants to keep this liability in place. Now, saying like, okay, well, there's the potential to have to hold this for 9 to 12 months. People really, really get nervous about it, escrow agents. So, and I don't blame them. So basically what am I telling clients now? We've had a lot of people come to us right now, especially foreign clients. I think we're only going to see this increase because they're going to be able to travel back to the US. And they say, well, what should we do? Should we do a certificate of withholding applications? Because they're getting information from all different sources. They hear about this early refund application and they say, well, we want to do that. And I'm telling clients, well, it depends. If your closing is going to occur before the end of the year, before December 31st, 2021, then I would just have the withholding sent to the IRS. And the reason being is because once the money is sent to the IRS, right, the IRS will send back proof that they have the funds. And then beginning in January, right, and we're only, 3 months away from January now, beginning in January of 2022, end of January, they will be able to file an income tax return, right, asking for a refund. They file that income tax return. And again, look, the IRS is not going to work fast. That's still going to take several months, but they're probably looking at, 3 to maybe 6 months to get that refund. So they'll probably see a refund in June. Who knows with the IRS, right? But they're probably going to see that refund by June, right? If they do a certificate of withholding application today and a FIRPTA escrow today, and it closes, and the property closes before December 31st, 2021, then what's going to happen is they're going to be waiting for a response for the certificate of withholding up until potentially up until September, October of next year, right? And then even then, the IRS could deny that certificate of withholding application. And what happens in the meantime? Those funds are withheld in escrow, are maintained in escrow. So they can't ask for a refund in January, right? So they might wait an entire year just to get denied and then have to go through the regular refund process anyway. So what I'm saying is don't do the certificate of withholding now. Just wait until January to file a regular tax return, have the withholding sent in. Now that's going to change because in January, I'm going to start saying, well, I think a certificate of withholding application makes sense because then in January, if you sell a property in January 2022, you're not going to be able to file for that income tax return until January of 2023. So then it makes more sense, but it's all a timing right now and everything's in flux, and with backlogs, it's like you really don't know where the IRS is going to be at. So what are the
Chris, no, one last thing, sorry, to point out is that like we can use the certificate of withholding not only to exclude the tax, but also to reduce, right? So just to point that out.
Yes, correct, yeah. So what are some potential strategies to avoid the FIRPTA withholding? All right, so one thing that we like to do is we like to structure it from a lot of clients to create a two-tier level system, corporate tier. One is that offshore blocker entity, right, that protects against US estate tax. But then on the next level, we have a US corporation that's wholly owned by the blocker entity. Because in that way, the US corporation, which is a US person for FIRPTA and income tax purposes, purchase the entity. When it sells it, there's not going to be any FIRPTA withholding. They can give that non-foreign affidavit, right? Because the US corporation is a US person. So that eliminates the FIRPTA withholding. You can also utilize it using a partnership entity, for instance, an LLP or an LLC with more than one member. If an entity, for instance, is already in the name of an LLC, then what we've done in the past is, and this is before closing, by the way, okay, we don't want to engage in any sort of fraudulent conduct or anything. But if we come across a client that has an LLC, and it's a single member LLC in their own individual name, then what we could do is we add an additional member. It could be a spouse, for instance, like a 1%. But the difference here is then that would be considered a domestic partnership for US income tax purposes and not subject to FIRPTA. And you can purchase it in the name of a US domestic trust or convert a foreign trust to a domestic trust. That needs professional advice. Nobody should do any of this on their own, any client, but especially that gets very, very tricky. And lastly, again, very, very tricky, but if real estate is owned by a foreign company, they consider selling the shares of the foreign company. Selling the shares of the foreign company isn't subject to FIRPTA. However, the buyer will receive the adjusted basis. They would inherit the adjusted basis. So they'd have to get some sort of discount for the tax. Just like Tony Blair, but there's another article, but I won't get into that because we're running out of time. I mean, the last option is very highly uncommon. We only really see that when someone's looking to sell it to a close member, family member, or a friend or a business partner, and they're both foreigners, because ultimately no one in the U.S. market is going to be wanting to buy shares of a BVI company.
But from all of those structures that we just mentioned, from all of these options, I think that the first one, especially with foreign clients, is usually the best one, because first, with the foreign corporation, we protect them against the US state tax. And also with the New York corporation, which is owned by the foreign corporation, we avoid FIRPTA rules. So usually that's definitely one of the best strategies.
Yeah, and it's also good from an income tax perspective. We can't go into that now. That's outside the scope, but there's several different benefits for it. But there are some downsides as well, because then you do create some tax obligations where they wouldn't otherwise exist as an individual. So everything's got to be carefully balanced out. So now finally we come to our obligatory disclaimer. This is just for informational purposes only. May not all be up to date. It's not legal advice, it's not your attorney. We would love to be your attorney though, so contact us, right? And questions. I think we've seen questions here in the chat box, so let me just open this up real fast. So first question is Rebecca. What if the 8288B has already been sent, closing has taken place, seller's only option to wait for IRS decision? Can they file the return in 2022, prove loss, get the escrow back? So Rebecca, so what happens is that as I had mentioned, once the 8288B has been filed and it's in escrow, then the only alternative is to wait for the IRS to make a decision on the application. They can still file a tax return, but when you file a tax return, it's two completely separate procedures in the IRS. You have the FIRPTA division, and then you have people that deal with the income tax returns, and they don't talk to each other. Trust me on that. I have plenty of experience with that. So they could file an income tax return, but with the income tax return, to get a refund, you need to, from the income tax return division, you need to file Form 828, a copy of Form 8288A stamped by the IRS showing that the refund was actually sent in. And if you don't send that in, then you could send in the tax return, but you're not getting a refund, right? So because they have to match the tax return with funds actually sent in. So if someone's already sent in an 8288B application and they're waiting for it and now they're concerned about the backlogs, what I'll say is, well, first, it depends. If they just sent it in, it might make sense to just say, you know what, never mind about this. We sent it in, but let's actually just send in the withholding to the IRS. There's nothing wrong with doing that. You can send it in even while the 8288B is pending and go the refund route, right? Unfortunately, note that we don't have any ideal solutions. The 8288B was a great solution, and now with the backlog, it's screwed everything up. So there's no real fast way to get the money right now. Hopefully they'll clear the backlog within the next year or so. But it's kind of a wait and see approach at this time. I hope I answered your question there. Next question from Greg. Would it be advisable to file the tax return without the form 8288A or wait, assuming still before the deadline of extensions? So it's Greg, so it's sort of similar to my answer to Rebecca. You can, if you file a tax return, which you have to do anyway, that's required, that's mandated by law, no matter if you're still waiting on an 8288B decision, you have to file it, but you're not getting a refund unless that 8288-A form is attached, or at least there's some evidence that the withholding was sent to the IRS, and they can properly match it with the tax ID on the tax return with the withholding that was actually sent in with the tax ID on the 8288A. So yes, you can send it. You do have to send it anyway, but it's not going to do any good to getting a refund. Third question from Craig. Wish I met you sooner. I wish I met you sooner too, Craig. How did Canadian seller get hit hard with 15% withholding? Yeah, it's and you know what, Craig, there is a bit of a misconception as well with Canadians, right? Because we have such a close relationship with them, that all of a sudden they realize they're subject to the exact same rules as any other foreigner, and it does come to a bit of surprise to them. But unfortunately, that is the case. If you have any questions, if you want to go elaborate a little bit more, feel free to shoot me an email. I'd be happy to brainstorm, see where they are right now in the process. But if they sent in, Craig, if they sent in the 15% withholding, again, this isn't a tax on them, right? If they don't owe that in taxes, they're eligible for refund. They should file a U.S. income tax return. I assume that the sale was this year. If it was this year, they should file it in January of 2020. January of 2022, as soon as the IRS starts accepting them. If they have the 8288-A form, send it in with that and request the refund. I think that's the best thing they can do at this point. And they'll get their money back. It's just a question of time. And the IRS is so slow on these, so it's best to do it sooner than later, right? Also another thing that's really important is these tax returns should be filed timely, right? Because now you're not going to get, if you're an individual, you're not going to get any penalties, by the way. If the withholding was actually made and they owe less than the tax was owed, well, the IRS already has that money. So even if they file the return late after April 15th, they're not going to be owing anything, because penalties, at least for individual, foreign, and even foreign individuals, is only based on the tax owed and not paid, right? But they have tax, they have the money in there, right? So they could file it after April 15th without even filing an extension, and they won't be hit with penalties. Of course, it's going to take much longer for them to get their refund, but they should file it as soon as possible, because another reason why they should file it as soon as possible is there's a statute of limitations on requesting refunds from the IRS. I believe it's tricky, the concepts, but generally it's 2 years after they were required to file a return. It's around 2 years. So let's say, for instance, a return is required to be filed on April 15th, 2022, and then they don't get around to filing the refund return. And this has happened with clients of mine until, let's say, 2025. Well, they're out of luck. They're not going to get any money back, because the IRS places limits on when you can request a refund, right? And I actually had that situation where a client sold property, I think like in 2012, didn't file a return until, I don't know why, but didn't file a return until like 2016 at that point, and is still waiting for a refund for this day. And then he came to me and said, why am I not getting a refund? I told him, because it's outside of the statute of limitations. That's why they're not giving you the refund. and there's no recourse to that. Sooner. From Michelle, my understanding is that in the event of a 1031 simultaneous exchange, same day, FIRPTA does not apply. Can you confirm? So same day, that's a good question. I'm not sure, Michelle. I'm gonna have to look that up. The same day, I'm not an expert with 1031s. It's just I know for 1031s, I just wanted to put aside that misconception. The same day one, I'm not exactly sure. That's interesting though. Same day, is that very common to do same day where you find two properties and you're able to close exactly on the same day? How that's it's great if that actually works, but I feel like that's a pretty uncommon situation. But I might be wrong. But I can certainly look into that and get back to you. I'm curious about the answer myself. And a question from Bin. What happens if they are foreign when purchasing but become US citizens later? Bin, good question. So basically when it only matters when they actually sell it. It only matters when they're transferring it. So if they become US citizens at a later date and then they sell it, FIRPTA doesn't apply to their US persons as transfers. So yeah, no FIRPTA withholding at all. And I think that's it. I see some questions in Q&A. So there's a question here, Jacques Ambron. Any strategies for avoiding the New York State non-resident tax? No, Jacques, unfortunately not. If you're selling real estate in New York, then New York can also take a good bite out of the apple as well. So there's really no way of doing that. It has to be reported on ACRIS. The only way you can get around the mandatory withholding of estimated New York State tax is by declaring that you're a resident, and that's on the penalties of perjury. And if you're not a resident, I don't recommend doing that. So no, unfortunately not. New York State tax is going to be owed regardless. Just the reality we have to deal with living in New York. It's the price we pay, right? But Florida is a good option. There's no state income tax there, so maybe they want to consider Miami. Question from Elliot: can you withdraw an exemption application? Elliot, yes, you can. You can withdraw an exemption application. If you're looking to do the strategy of getting a refund through just a regular income tax return filing, then the best thing to do is just send in the withdrawal together with the 8288 and 8288A forms in to the IRS, to the Ogden Center, and then see that they can process that and then get the stamped form. Bear in mind, we're, like I said again, where I don't want to try and give any sort of silver bullets or anything. It's just my own personal opinion in terms of time frame. It's a really crappy situation we're dealing with right now with the IRS. Hopefully it gets resolved. I don't want to say that you file a refund request through a tax return in January, then you're going to get it within 3 months of that or something. Who knows with the IRS? They're all over the place right now, and it's really just because of they've been underfunded, they're understaffed, and now with COVID, it was never a great situation before the pandemic. Now it's even worse. So clients, unfortunately, are just going to have to be patient, and that's all we can really do, and try to manage their expectations as best as possible. And I think that's it. I think I've answered everyone's questions. So I think this is going to be the end of the present. Oh, hang on a second. I got read there's a withholding tax forms complete for New York State. Hi, Rebecca. Sorry, I just saw your question real fast. Yes, withholding tax forms complete for New York State. It's part of the ACRIS forms, by the way, Rebecca. These are typically completed during closing, right? So don't panic about that. It's very, very standard. It's mandated when you're recording a new deed to send that in. It's one of the forms that's sent in. I think it's I-2 IT2, I forget now off the top of my head, and there's a calculation in there and everything. So it's all part of the closing process. I wouldn't panic about that. All right. I22663. That's it. That's it. Thanks so much. All right. I think that will do. One more Q&A, I think. This should be okay. No. So I think that'll do it, guys. Thank you so much for joining. Any questions? Feel free to reach out to us, email, telephone. Oliver's going to send a follow-up email to everyone that registered with a link to the recording and also with a copy of the presentation as well. All right. This concludes it. Thank you so much. Thank you, Oliver.
Yep, thanks.